Thank you so much. We welcome you to this masterclass, and we thank you so much for kindly accepting our invitation. Of course, a warm welcome to all the participants. Welcome back, because this is the second day, in fact, day 2 of our e-masterclass. So today we have got an interesting session, and we have Mr. Abhishek Rastogi is a partner in direct tax in Khaitan and Company. So he will take us through today on the understanding of the FTP vis-a-vis constitutional issues, journey of REITs under foreign trade policy, FTP. Just to give you, Mr. Rastogi, mainly a quick background, on day 1, we have covered in detail the mechanics of FTP, nuts and bolts, incentive schemes, etc. There were 2 speakers on that day. But as I understand, even the issue which you are going to cover today is of utmost importance. So without wasting any more time, I will give the floor to you, and please feel free. Before I turn it over to Mr. Dastogi, for all the participants, I have got a request to make. Kindly put your questions on the Q&A box, I repeat, not on the chat box. And for those who are technologically handicapped or challenged like I am, that Q&A box is right at the next to that chat box. There is one facility with 3 dots. If you click there, you will get access to Q&A box. So request all the participants once more to kindly put your questions in the Q&A box. Repeat, not on the chat box. Mr. Rastogi, you have the floor. Please, all the best.
Thank you so much for the introduction. And I would want to thank, first of all the participants to give their precious time to us. I'm sure I will try to make this session very interesting. But before we go on to the constitutional aspects surrounding the foreign trade policy, I think it's very important for us just to take some steps back and see what's happening globally. Because see, understand that this foreign trade policy is nothing but the culmination of all of these different aspects which are happening at a global level, including at the WTO level. So if we go back to October of 19, if you recollect or if you're aware, India had lost in a WTO matter against the US, wherein the US had basically come up and said that India has crossed the GNP of $1,000 per capita, and hence India no more is in that situation wherein some of these benefits have to be given. So in October 19, a specialized panel constituted by the WTO recommended the withdrawal of several export promotion schemes. The reference was made to examine whether certain identified export promotion schemes by India were violative of the Agreement on Subsidies and Countervailing Measures, which prohibits member countries from granting or maintaining a subsidy, whether in law or fact, on export performance. So in nutshell, we know that what is happening between various countries, and I need not name that in terms of the trade wars which is happening. And when this is happening, India is being also watched very, very closely, whether these are developed nations or the developing nations or our competition. Each one of these countries are watching Indian trade policies very carefully and very, very critically, because they also know that India is playing a major role. So what happened in October 19 is when the US made a claim that the India's GNP has crossed the threshold of $1,000 for the periods 2013 to 15, and for the periods 2014
Sorry, I am coming in between. Sorry for that. All the participants, can you hear Mr. Rastogi, or it is the problem with at my end? My colleagues, Prerna and all, and participants, can you hear Mr. Rastogi properly? Prerna?
Sir, I think there is some bandwidth issue from Mr. Rastogi's side. Bandwidth is not stable.
Yeah, Mr. Rastogi, can you hear me now?
I can hear you.
Yeah.
Should I?
So then, yeah. So what I would request, if you don't mind, maybe there is some network issue. If can you, for at least for some time, can you shut down your video? That will improve. That is just by way of suggestion.
Yeah, that's what I've done. Is it better now?
Yeah. So I think now good enough. Sorry for that. Sorry to come in between.
No problem. No problem. So
now it's okay.
So basically, when we have to see these prohibitions which are to be imposed, there are two most important aspects which need to be seen. One is maintaining a subsidy which is contingent, and it has to be contingent on the export performance. So those two factors were very, very relevant and which were very, very closely debated. Now, what claim US had made? US had made a claim that India has crossed the GNP of $1,000 for specified periods, and hence it would tantamount to subsidies. And hence there was a question whether our scheme related to EOU, EHTP, STP, biotechnology parks, SEZ, EPCG, and MEIS, whether the benefits should be extended to all of these policies. And also, apart from this, duty-free import schemes, which are specified 9 such schemes in the Customs Notification 50 of 2017. The question was raised with respect to those schemes as well. What was the submission made by India? India was very, very smart and categorical to say that export promotion schemes do not qualify as prohibited export subsidies, which means that India was very, very clear that what India is giving to the Indian exporters is not the prohibit export subsidies, but it is a permitted duty remissions. So from that perspective, I think India made a very, very clear distinction between the prohibited export subsidies and the permitted duty remissions. So from that perspective, it was very clear that India was clearly defining it to be covered under the permitted duty remissions. And whether you call it a thin line of distinction or a thick line of distinction, but clearly India maintained that there is a line of distinction between the prohibited export subsidies and the permitted duty remission. So what was the other submission by India? India said that there is no violation of Article 3.1a and 3.2 of the SCM, as it enjoyed an exemption for 8 years upon graduation as well under Article 26 of the SCM. The literal reading of Article 27.2 of SCM, however, indicates that a reprieve was granted to developing countries for 8 years from the date of the WTO agreement coming into force. So from that perspective, India maintained its two grounds. Unfortunately, the panel decided against us, and the panel held that these schemes would qualify as prohibited subsidies. And hence, as a result, it was announced by them that India will have to phase out all of these schemes which pertain to EOU, EHTP, STP, biotechnology parks, EPCG, SEZ, and so on and so forth. What was very interesting is that as far as this final order was concerned, report has not been accepted by India, which means that India was very clear that we would maintain our stand with respect to that these schemes are not prohibited export subsidies, but permitted duty remissions. Now, which means what? India appealed against this order within the stipulated time of 60 days. And hence, as we speak, there is no obligation on the Indian government to basically remove these benefits for the Indian exporters. But what happened after this ruling? It's very, very worthwhile to note. It opened the Pandora box for the thought. Now, India has been moving very gradually towards the globalization and the WTO policies. What India has been doing is on 3 fronts. as far as the MEIS is concerned, it will be gradually phased out. And that is completely in line with the international global standards and to meet the WTO norms in case India lose at the appellate forum. That is with respect to the MEIS. With respect to the SEIS, decision on continuation of SEIS for 2021 and so on and so forth would be taken very fast now with respect to these extensions, whether these will come and in what way these will come. Interestingly, as the entire debate was with respect to the prohibited export subsidies versus the permitted duty remissions, we have to gradually and slowly move towards the model of duty remission so that we could probably show that there is being laid. And as I based rewards. Now, as you would be aware, that remission of duties or taxes on export products scheme would come into effect very soon, which will neutralize this aspect, which will ensure that India basically goes into the model wherein the remission model comes into play rather than the subsidy, which is contingent and is based on the export performance. So from that perspective, I think it was very interesting to see that India maintained its stand. We are today at the WTO Appellate Forum, and I'm sure we will be able to justify the country's stand. But now, how does it make a difference to the Indian exporters? Or is there something to worry for the Indian exporters? That's the question mark today. That's the moot point of discussion today. Now, if we see the intention of the legislature, and that's what we will be coming to in the subsequent part of this session, that most often the intention of the legislature is to give the benefit to the Indian exporters. What happens is when the interpretation by the executive is not in sync with the intention of the legislature, and that's when the problem arises and judicial intervention becomes necessary. Because it is only the judicial intervention which would sync the intention of the legislature and the interpretation of the executive. Now, even if you see the dispute at the global level, which is with respect to a lot of these policies, the dispute is not with respect to some of the policies such as advance authorization. But if we see a lot of these matters have gone to the court with respect to advance authorization, and I would come to that in a while. But before we go to specific details of a lot of these matters which have gone to the court, I think it's also very important for us to understand that what is the role of the equity jurisdiction as far as the foreign trade policy is concerned. And when I say equity jurisdiction, I would want to explain that when these matters go to the court, what court has to see is the pure law, or could it be also logic? Could it also be that whether benefit has to be extended to the Indian exporters so that the country earns foreign exchange? Could there be a case wherein there is a hardship for the Indian exporters, which was not the intention of the legislature? So I think when it comes to the tax jurisprudence, role of equity jurisdiction is very, very limited. Logic comes to play very rarely, and it is the law which comes into play more often. But in most of the writs, which at least I have argued, I have always used logic as well. We have tried to show to the court that there is a situation of undue hardship which is being faced by the Indian exporters. And while the Indian exporting community is struggling at various levels due to various different hardships, external competition, roadblocks, etc., which is happening, these are the policies which are given or which have been announced solely for the purposes of benefit to the Indian exporters. And if the pith and substance has to be seen, it has to be seen with heart as well. So coming on to some of these petitions, I think it is very important for us to understand that most of these policies or most of these notifications or benefits are issued in public interest. Now, that's the legal point as well. Because if something has been done in public interest, it needs to be extended in the public interest so that the benefit continues at least for that period for which it was announced. And most of these problems today which arises wherein the judicial intervention becomes very, very essential is with respect to such issues. So I would first of all take the petition which I argued in Delhi High Court with respect to advance authorization. When the transition happened from the erstwhile regime to the GST regime, there were restrictions under the advance authorization and the related provisions of the foreign trade policy to give restricted benefits for duty imports under the advance authorization licenses. Now, as far as the facts are concerned, these were the licenses which were issued prior to the introduction of GST. The fulfillment of the export obligation had to happen subsequent to the implementation of the GST. So the moot point before the court was whether the licenses which were issued prior to the implementation of the GST, could IGST be levied for those transactions of imports wherein the Indian exporter and the importer already has a valid advance authorization license. When the transition happened to the GST regime, this benefit was curtailed and no benefit of duty-free import was given as far as the IGST was concerned. The matter was taken to the court, and when I argued before the court, I think I still relied on the equity principles. And I said that today the Indian exporters are facing a huge problem of working capital. And the entire objective or the rationale behind these incentives was to ensure that the Indian exporters do not face this problem of working capital. And these schemes probably neutralizes the entire tax chain in the sense that these are all revenue neutral taxes, because as the Constitution provides, the taxes cannot be exported. Now, if the Indian exporter has to make these exports and you make these imports taxable, then that's just revenue neutral because he will ultimately get the refund of these taxes. But there is a big problem of working capital. And we know for a fact that for a lot of these refund issues, the tax paid to the government does not come that easily, and there is litigation and compliance cost. So from that perspective, Delhi High Court passed an interim order somewhere in August of 2017 to clearly lay down the principle that these schemes were predominantly issued to ensure that the working capital requirements of the Indian exporters are met. That was the objective. And if the Ministry of Finance and the Ministry of Commerce are not in sync with respect to these schemes, with respect to the that was not only the first writ petition under the GST regime, but also one of the first writ petition with respect to curtailment of these benefits under the foreign trade policies and different benefits which were extended to the Indian exporters. The good point, fortunately, thereafter was that between the time the interim relief and the final order of the Delhi High Court, the government understood the bigger problem. And I think applaud Ministry of Commerce, who proactively understood the issue, took the representation on board, because they were also sure that after a dozen of these writ petitions, there'll be thousands of such writ petitions which could come to the court. And they rectified and amended the provisions to extend this benefit of IGST to all of these advance authorization schemes. So that was a big win in terms of the government also supporting the Indian exporters subsequent to filing of these writ petitions. Just a moment back, I mentioned that sometimes the problem happens when the intention of the legislature is to give the benefit, but the interpretation of the executive is something different. And that's exactly what happened post this order, because as far as these petitions were concerned, or as far as this advance authorizations were concerned with respect to continuation of this IGST exemption, there was an amendment. So there was no problem to that aspect. There was also no issue with respect to the because what happened was that this interim order thereafter was finalized by Delhi High Court. And once this was finalized by the Delhi High Court, the SLP was also dismissed of the revenue. So as far as this law was concerned, or this fact was concerned, it was all perfectly okay for the Indian exporters. But then what happened thereafter was that the executive interpreted the condition which was made applicable for these advance authorization, and that condition was nothing but the pre-import condition. So what happened is that when this benefit was extended to the Indian exporters, there was a condition which was imposed, and that condition was that the Indian exporters would fulfill the condition of pre-import. Now, what that pre-import condition is, or how that pre-import condition was defined, nobody knows, because it was not defined. And that's exactly our next level or next round of litigation was. He said that this pre-import condition, which is now being made applicable to advance authorization licenses and for import duty-free, is actually vague. How do you define pre-import? The term pre-import means that import precedes something. Now, import precedes the manufacturing, or import precedes the export of the goods, or import precedes what exactly was not defined. And hence, it was argued in Gujarat High Court, and in half a dozen of these different courts, I argued that this entire condition of pre-import, which has not been defined, is so vague that the doctrine of void for vagueness will have to come into play, and will have to say that this condition is actually vague. Again, the question which was raised before different courts, that what was the intention of the government? And what happened actually after multiple such petitions were filed, that in 2019, even this condition of pre-import was removed as far as its applicability was concerned to the Indian exporters, which means that only for the period between October 17 to January of 19, the condition remained relevant. So the good point was that subsequent to filing of these writ petitions, the government understood that such a condition is creating a challenge for the Indian exporters, and government again proactively made the change to amend the foreign trade policy and to amend the customs notification so as to remove this condition of pre-import. The moot point which remained there is with respect to the intervening period or the interim period of 1.5 years, because there were multiple show cause notices, DRI investigations with respect to non-fulfillment of this pre-import condition. And hence, there were multiple writs in different courts which were argued, which were, on this aspect. And one of the very, very key point there was with respect to what happens to the public interest. If there wasn't a condition prior to coming into this notification in force in October 17, and there is no such condition even after January of 19, how is it possible when these notifications are issued in public interest that it is only for the relevant intervening period that the public interest aspect can be missed? How is it possible that as far as the public interest is concerned, that this condition was relevant or is relevant only for this interim period? And as I mentioned, that most of this litigation or most of this these notifications with respect to these benefits are issued in public interest. So that needs to be defined as well, that whether for imposing such a condition, is there a supervening public interest not to grant that benefit for a specific period? And that's where Gujarat High Court also felt that this condition of pre-import is ultra vires the foreign trade policy. So Gujarat High Court boldly went ahead and said that this condition is ultra vires and is actually not constitutional. So that laid the foundation for a lot of these schemes, what benefits have to be extended, whether these benefits can be curtailed. But of course, all of this came with a cost. The litigation cost for the Indian exporters was not less. The compliance cost, the cost of providing this data to DRI, to provide this data to the jurisdictional commissioners, etc., is not less, because a lot of harassment, lot of compliance, lot of data was to be furnished. So it was not easy for the Indian exporters. And after this Gujarat High Court favorable decision to held this pre-import condition to be unconstitutional, of course, the matter today is before the Supreme Court and will ultimately be decided by Supreme Court. And what I understand today, in fact, today in the morning only from one of my clients, that the revenue impact on these transactions is, I think, to the tune of 1,600 crores. Now, my point is that, one, this is revenue neutral. Secondly, this matter is sub judice. So even if the show cause notice is issued, ideally those should be transferred to the call book, because when the matter is sub judice, the jurisdictional commissioner should not decide on the issue. There is, of course, a requirement for amendment of these petitions so as to include these show cause notices, take appropriate measures to take stay either on the proceedings or these show cause notices. Payment, if is to be done, whether that payment can be done under protest is again a question mark, which is to be seen. And also, if it's a revenue neutral transaction and if availment of ITC is there, then at what stage this proceeding should be concluded so that the availment of credit comes as a natural corollary to the entire problem. The related problem is with respect to the question of redemption of these impugned licenses, because if you see the entire period that's divided for the licenses which are issued prior to 1st of July, licenses which are issued in the period from 1st of July to October 13 of 2017, and all of these licenses which are issued post October 13 of 2017. So what is the status of all of these, all of the redemption of these impugned licenses has to be seen. If redemption of the impugned licenses has happened, and there is now a question on that redemption, is there a legal remedy for the Indian exporter to again go back to the court and say that the redemption of these licenses has happened? And hence, it is not possible today for now the authorities to say that the condition of pre-import is applicable or is not fulfilled. In a lot of these cases, what has also actually happened factually is that the pre-import condition has been subjected to exports both prior to the import and post the import. So for instance, when you obtain the advance authorization licenses, that license is based on an export which is already concluded, which is already done. So based on that export, you get a license, advance authorization license, and based on that license, you import. Now, after you have obtained the license, if there is a condition of pre-import, which DRI or the jurisdictional authorities are defining as an import which should precede export, so why at all was the advance authorization license given on the basis of the export which was already done? In spite of this, a lot of players, what they have done is they have done double exports. What they have done is ideally they have exported the goods. The finished goods export has happened. Based on that export, these advance authorization licenses have been received. And basis this advance authorization licenses, the inputs which have been procured duty-free, again exports have been made of these products for which the benefit has not been taken. So was that the intention of the legislature? Was the intention of the legislature was to make double exports relevant for each of the import which is being done duty-free? Will be the moot point before the Supreme Court. And I'm sure the intention was at every stage of the Indian government to promote the Indian exporters. And if that was the intention, that the Indian exporters have to be promoted, reason that why this provision, which today leads a clear hardship in terms of the double export for an import which is done duty-free, why court should not intervene and why these matters should not go to test the constitutional validity. So I think that's been an interesting journey as far as the advance authorization licenses are concerned, as far as this pre-import condition is concerned. I'll take a pause, and in case you have a few questions, I can address those questions on these aspects and then probably go ahead. I can see some questions which have come.
Yeah, certainly you can take few of the questions, you can respond. Then you are free to do that, Mr. Rastogi. Free to.
Yeah. Oh, actually, my Q&A box is hidden, and I'm not able to reach that box. I could see some questions being posed.
No, I will ask my admin colleague to know. I don't think that should be the case. Just a sec. Chetan, Chetan, can you hear me?
I can see the participants list.
Yes, sir.
But I am not able to see the Q&A.
Q&A box, you can see.
So when you just click on that three dots on the bottom,
Yeah.
then on the top there is a blue button Q&A. You have to just click on it.
I'm not able to see that.
No, I'll tell you. On the right side of the chat sign, that icon, there are three dots.
Yeah.
So please click on the three dots first.
There is one raise hand. There is another feedback, and there is last one.
No,
attention.
On top there will be Q&A. There is a box. If you kindly click on that three dot, that round circle.
No, those are not there actually.
Not there. Chetan, can you help Mr. Abhishek, please?
Are there any questions? Can you read the question?
Yeah, I'll try to do that. Just a sec. I'll try to do that.
Yeah.
I'll. At the moment, let me. Okay, let me. Can you hear me? Let me read out the first question which I have found.
Yeah.
This is: Can the duty credit scripts MEIS, SEIS be used for payment of concessional duty for import done through project imports route? That is the first question.
I'm covering that in my subsequent writ petition aspects.
Okay, thanks. So moving on to the next. Next question is: when GST exemptions allowed in August 2017, it was only for physical exports. It's now applicable for deemed exports too, when pre-import condition is just a second, pre-import condition is removed. So I will repeat. When GST exemptions were allowed in August 2017, it was only for physical imports. It is now applicable for deemed exports too when pre-import condition is removed. So I think that's an observation. I can't see the question, but if we go to the next one.
Yeah.
If we, some questions are coming in, but I think the connectivity is poor here as well. Let me just.
No problem. I think a lot of these questions are related to the points which I will be making on these aspects. So I think I can continue with that, and I'm sure and I have also shared my screen now, so that some of the
Let's do
content.
that. And then after your PPT is over, presentation is over, either me or my colleague Ira can read out few more questions where I'm left. Okay.
Sure.
Please
And in
go
the
ahead.
meanwhile, I've also sent the picture of the screen which I'm getting, on which there is no Q&A which is coming.
Okay, fine, no problem. You can, over to you again, over to you.
Yeah, sure. So I think as far as this pre-import condition is concerned, it was very important for a lot of these Indian exporters to understand a lot of these related issues with respect to the rates which we have put here. So, and I think as far as this Q&A session is concerned, we will ensure that most of these questions are addressed towards the end. But then moving on to the next point is with respect to the physical export on EPCG licenses. And what this issue basically is that the physical export on EPCG licenses has been a subject matter of issue before the Delhi High Court in writs which are there argued by us for insertion of the physical export condition. Now, what has basically happened is that this physical export condition has been a subject matter of dispute, is because this limits the benefit for the service providers. So, for instance, if there are the EPCG license holders, and as far as the export obligation or the fulfillment of conditions with respect to the export obligation was concerned, these service exporters had certain categories of services which would qualify for meeting the export obligation. And in between, if there is a change in the policy, and the change in the policy is such that it limits the benefit for service providers who provide specified services, and that benefit is restricted with respect to these services, then they will never be able to meet the export obligation as far as their licenses are concerned. So the question which now again arises is that, can this amendment, which appears to be prospective, be made with respect to fulfillment of the export obligation? And in fact, if you ask me, in effect, the implication is that the impact of the change in law with respect to the EPCG licenses gets extended to the actual licenses which are issued as on the day of the change. And when the licenses were issued, at that point of time, there was no condition that there has to be only physical exports, and the services would not be treated towards meeting the export obligation. And hence, when one of this petitioner came to me, we said that the best recourse is to take the matter before the jurisdictional high court. And I argued this matter before Delhi High Court to basically substantiate that at the time when this EPCG license was issued to me, at that point of time, there were definites in the export obligation meeting criteria as well. And those definites today are being removed for me to make the export obligation or to fulfill the export obligation. And if that's the situation, and I am a sole or an exclusive service provider without making any physical exports, it will be not possible for me to meet the export obligation. And hence we challenged that provision so that this benefit could be extended for EPCG licenses, or these benefits are continued for the EPCG license holders with respect to meeting the export obligation with respect to those services. So that was there before the Delhi High Court. Interestingly, the same aspect which was very, very important was with respect to the retrospective amendment with respect to the foreign trade policy. And before we go to the retrospective amendment, I think let's just understand these retrospective amendments and the retroactive amendments which have been the moot point of discussions, whether these could be made applicable to these policies at the time when these licenses were issued, or at the time when the benefits under these policies or the schemes had to be taken. Now, before we go on to that, retrospective amendment can happen idly in the rarest of rare cases, which means that only in those rarest cases wherein the law has been misused, or it appears that there is a clear misuse of power, or there is some unintended omission which has happened, only in those circumstances which under the tax jurisprudence are referred as rarest of rare tax cases, the retrospective amendment should ideally come into play. Now, what has happened with respect to validity of this retrospective amendment in terms of the foreign trade policy? And Apex Code, in a beautifully worded order, said that the Section 5 of the Foreign Trade Development and Regulation Act conferred upon the central government the power to notify and amend the foreign trade policy. It did not empower the central government to do so with retrospective effect, which means the question before the Supreme Court was whether Section 5 will have the retrospective effect or not. And it very, very categorically and clearly held by the Supreme Court that the notification lowering the duty credit entitlement to exporters under the Target Plus scheme would be applicable only prospectively. So the point here was that whether this Target Plus scheme, which was announced by the government, could the impact on those Targets Plus schemes could be done retrospectively, or when these announcements or changes are being reduce the quantum of the benefit under these Target Plus schemes, will that be only prospective? And Supreme Court did not shy to say that no such retrospective amendment can happen with respect to these Target Plus policies. And I think that was a big relief for the Indian exporters, because that proved very clearly that the judicial intervention would happen in those circumstances wherein these schemes were announced, and based on those schemes, the Indian exporters acted or had these pre-orders. So I think it was a very, very welcome decision, which was laid down a lot of principles, as the Supreme Court also held that the notification laying down products, the export of which would not be considered for fulfillment of export obligation performance, would also be applicable prospectively. So I think from that perspective, it laid down not only the view of the courts with respect to this Target Plus scheme, but also the view of the court with respect to these policies and these schemes, whether how these amendments could happen, and when these amendments are happening, could it also mean that the scheme which has been already made implemented for the Indian exporter, would it make an impact in such a way that at the time when this benefit was given and was promised, whether there is any curtailment with respect to the benefit at that point of time. And I think when I say that this Supreme Court decision has laid down the fundamental basis or fundamental principles, has also been referred to a lot of such similar issues, for instance, in the Punjab and Haryana High Court, which relied on the Supreme Court decision. And here the dispute was with respect to the duty-free import authorization, which is, of course, governed by the foreign trade policy. And the question was whether, as on the date on which such DFIA was issued, whether the benefit could be curtailed with respect to these licenses subsequently. And hence, any subsequent amendment in the foreign trade policy would not govern the entitlement under the DFIA. It was very, very clear that at the time when these licenses were issued and at the time when these changes are made at a subsequent date, whether these changes are made in such a way that there is an impact on the licenses or the schemes which were pronounced or announced at an earlier date, whether there is any curtailment with respect to those benefits at that point of time. So I think from that perspective, a lot of these decisions of different jurisdictional high courts, or with respect to the Supreme Court in trade of the in case of the Target Plus schemes, laid down the broad principles of when these amendments could happen and whether these amendments could happen retrospectively or only prospectively. So then, of course, I mentioned about the target plus scheme, wherein the Supreme Court gave that benefit to the Indian exporters to say that any such curtailment of the benefit or the entitlement would not be reduced with respect to the target plus schemes, and hence this benefit has to be extended at the promised rate to the Indian exporters. And there were specific orders for these target plus schemes which were issued for the Indian exporters. But the unfortunate part is that in spite of these orders from the Supreme Court, there were a lot of these cases when these benefits were actually not being passed on in spite of the orders. And we moved on to the Bombay High Court in a couple of these cases, wherein we got the directions that the department should act within a stipulated time to give these benefits to the Indian exporters who were forced to go to the second round of litigation in spite of having a favorable order from the apex court. So sometimes it is unfortunate, but the beautiful part is that the Indian judicial system is helping the Indian exporters in a lot of these critical situations. Of course, in some cases, it becomes time consuming, but till the time there are situations wherein the interim order received, it gets some sort of relief for the exporters. The next issue is with respect to the restrictions of rebate benefits for exporters availing benefits of certain schemes. So as we know that today there are two benefits, there are two options in terms of the benefits for the Indian exporters, which could be by way of a rebate option or which could be by way of a refund option. Refund is nothing but your unutilized taxes coming back to you. Rebate is when you pay taxes on your output side on the exports and you get the amount back from the government based on the amount which you paid on the exports. The rebate option is beneficial in terms of the quantum in some cases because there is no restriction of the formula. It becomes easy. You utilize all your credit pools. So a lot of these cases, it happens that the Indian exporters prefer to go under the rebate option instead of the refund option. The point which was very relevant was with respect to the restrictions which were placed with respect to these rebate benefits. And there were certain identified schemes, such as the advance authorization schemes, the deemed export benefits, and certain other benefits. The question was, when the Indian exporter is claiming the benefit under such schemes with respect to the procurement of goods on the input side, can there be a restriction of rebate option with respect to these exporters on the output side? The matter has finally been concluded before the Gujarat High Court, wherein I argued for a couple of days before Gujarat High Court. The order has been reserved. We are hoping that the order will come soon to give this relief to the Indian exporters. But yes, there was a big question mark on whether this option of rebate benefit could be curtailed for the Indian exporters when they are making certain purchases under different schemes, such as advance authorization schemes. So let me explain a bit here. So for instance, if I am an advance authorization license holder, I am eligible to import goods duty-free. That procurement cost is reduced for me because these are revenue neutral procurements. This would in any case come as a refund to me. The question is that if I am eligible for the benefit of procurement at nil rate of duty under a specified scheme such as advance authorization scheme or deemed exports, can there be a restriction on me with respect to the option of rebate versus refund which I get on my output side? So that's predominantly the question. So from that perspective, I think it was very important that courts intervene in such a case, and that's exactly what happened in this case, wherein the matter was finally heard on the constitutionality of the restriction with respect to those Indian exporters who are making a claim or using those benefits on the input side. So that's an interesting aspect which was there before the Gujarat High Court. The next point which I want to take is with respect to the export prohibition of certain goods. And it is a fact that today there are certain export prohibitions which have happened. Some of these may be right and are very relevant in terms of this COVID situation. And we know that the government has done a good job so far to manage the trade deficit in some cases, to ensure that the domestic supply of certain products, especially medicine, etc., is monitored in such a way that the benefit comes to the Indian consumer. But the moot point here remains is that with respect to these export prohibition of certain goods, for which there is no scarcity in terms of the supply to the domestic manufacturers, would the export prohibition be a good idea without completely going into the merits of the product? So, for instance, we understand there is an export prohibition on masks. That is quite understandable because, or for that matter, ventilators and other products which are required for indigenous consumption. But what happens with respect to those products which are nothing but raw material to make these masks? And the moot question which arises is that if there is ample supply of such goods or the raw materials to make the final products, then would it make sense to restrict or prohibit the export without going into the technical analysis of what the product is, how much restriction should be put? And also, the related point which comes up is that with respect to these units which are located in an SEZ, whether these restrictions could actually come into play with respect to these units. All of these restrictions can come to SEZ, but with respect to the prohibition of these exported goods, there is a board of approval which is there, which has to mandatorily give an approval with respect to these prohibited goods as far as the units which are situated in SEZ are concerned. Because one, from the perspective of the SEZ, it is very, very relevant to ensure that their export happens continuously, because they have to maintain the positive NFE for every year. That is one. Secondly, they could have entered into various such contracts wherein the force majeure applicability may not become applicable, and they may be liable for these contracts getting cancelled, employment generation, and so on and so forth. So that's the intention of the law as well when it comes to the SEZ provisions. And in a lot of such situations, it has happened that even the units which are located in the SEZ units are not able to export these prohibited goods in spite of the specific provisions that these goods exported after the approval from the board of approval. And by the way, the approval is supposed to be mandatory because they are supposed to give that approval to these units. So from that perspective, whether these units, when they apply to the board of approval and these matters are not coming before the board of approval for whatever reasons within the stipulated time, there are a lot of such challenges which need to be looked into, and for which we are arguing matters in courts for these export prohibition. And it will be very, very interesting to see how the courts will intervene, whether the courts will be inclined to give some sort of a relief in the interim, because if such interim relief is not received by these SEZ units, especially in circumstances where the board of approval is either not sitting or the board of approval is not taking such items on the agenda, then it becomes a big problem for the Indian exporting units in the SEZ, and the entire purpose of setting up these units in the SEZ will go for a toss. The next point which I want to address is with respect to blocking of MEIS portal owing to fund allocation, and I think there was some question also with respect to the MEIS. There are a couple of aspects with respect to MEIS which I will take, but the first one which I would want to cover is with respect to challenging this provision for blocking MEIS portal owing to fund allocation. Now, what is being happening lately is that there are high allocation of funds for continuation of these schemes and which did not result in the proportionate growth in the export volumes and so on and so forth. So what has basically happened is that there is a decision which has been taken by the government that there will be some curtailment which will happen, and there will be a limit which would be set in with respect to the budget allocation for these MEIS schemes. So the question which now comes up is that can such blocking or with respect to the portal or with respect to the benefits can happen as far as the fund allocation is concerned. So the Ministry of Commerce is requested the Ministry of Finance to consider the budget allocation. Now, this entire problem appears to be a discussion between the Ministry of Commerce and the Ministry of Finance. But the moot point which remains is whether the Indian exporter will be the scapegoat who would basically suffer because of this non-clarity on this issue. As far as the technical aspect is concerned, this blocking of MEIS portal, which is nothing, and the reason which has been given is nothing but the fund allocation, whether that needs to be challenged. And I think that needs to be challenged because when these units are being set up, when the business decisions are being taken up, or when, for that matter, even the orders are placed and these pricing is done, all of this pricing, we know for a fact today we are competing with a lot of our neighbors and other countries. A lot of these pricing for the pre-orders happen on the basis of all of these benefits which would come, including the scheme under the MEIS scheme. So if that's the case, then of course, taking this matter to the court to basically prove that the pricing and the costing is relevant and this benefit cannot be curtailed because of some challenge between the two ministries of the same government will remain a question and will be the moot point of discussion before the courts, whether in those situations could the exporter be made to suffer or forego benefits solely on account of disputes between the two different ministries. So I think very, very clearly, it is my personal view that the action of blocking the MEIS portal appears to be ex facie illegal. And I would go to that extent to say, because at the end of the day, the resultant is the denial or the curtailment of the benefit to the Indian exporter. And that was never the intent. So we all understand that all stakeholders are facing tough times, whether it is the government, the tax collectors, the executive, and even the businesses. But I think once this benefit has been announced and once this benefit is eligible for the Indian exporters, it becomes very, very important and relevant for the government to put that in place in such a way so that none of the Indian exporters in these tough times is basically facing the challenge of denial of these benefits, wherein the intention was very, very clear to give these benefits to the Indian exporters. The next point which I would want to take is with respect to the conflict of the DGFT instructions. There are cases wherein there is a conflict of the DGFT instructions with the provisions of the foreign trade policy. And first such issue is with respect to the advance authorization restrictions for the gold exports. Recently, Delhi High Court quashed a public notice issued by DGFT, which restricted issuance of advance authorization for export of certain gold products. So the question which was there before the Delhi High Court was whether these advance authorization restrictions be made applicable to export of gold, and that too by way of this DGFT instruction. And the court was very, very clear that this benefit cannot be curtailed by issuing a public notice which had effectively amended the foreign trade policy. So the court had to intervene and say that the notice or a public notice which has been issued by DGFT cannot perhaps result in such a way that there is an amendment to the policy, and which is clearly beyond the powers of the DGFT, because otherwise what would happen is all of these public notices would be issued whenever the curtailment of the benefit is to be made. So With respect to this conflict of DGFT instructions, the Delhi High Court quashed this public notice. Another issue which came before the Delhi High Court was with respect to the restriction of refund of terminal excise duty for supplies to EOUs. And here the case was that again Delhi High Court had to set aside the public notice with respect to the foreign trade policy, specifying that refund of terminal excise duty should not be provided in case when ab initio exemption was available from central excise duty. So the point here was whether this benefit of refund of terminal excise duty could be restricted in this case wherein there is an ab initio exemption. And here again, the court has gone ahead to give the benefit to the Indian exporters to expressly provide that refund of terminal excise duty to the recipient can be availed when there is a duty exemption from that perspective. So the court very, very clearly observed that the subsequent amendment to the foreign trade policy, which restricted the refund, was substantive and could not be said to be clarificatory since it affected the vested rights of the SSC. Also, I think it is very interesting and relevant for us to understand with respect to the vested rights, which has nothing to do with this case which we are talking right now with respect to the restriction on refund of terminal excise duty. But very, very recently, with respect to the vested rights, especially with respect to the credits, Delhi High Court has passed a speaking order in my case, in case of brand equity. It's a beautiful decision which is to be seen, wherein the concept of vested right with respect to the input credits has been analyzed by the court. The court, in fact, has gone ahead to say that this vested right is not restricted to the period which is specified in the rules or the delegated legislation. In fact, the court have very, very clearly said that the period of limitation of 3 years, which is as per the Limitation Act, would be made applicable when it comes to the credit with respect to the vested rights. It's a beautiful decision to be read. Also because it goes on to say that the respondents will be responsible to publicize the order of the Delhi High Court so that the benefit is not restricted to the petitioners which were there before the court. So the decision was not for the petitioners, but got extended to all of the Indian business players who had vested right in terms of the transitional credits or other credits. So a decision worth to be seen with respect to the vested rights. It lays down certain principles. Most of the provisions when it comes to the foreign trade policy comes at a time when these schemes becomes applicable. They become applicable also at the time when the person gets the license. So whether there is a vested right in those schemes or whether there is a vested right in that license at the time of the issuance has been a subject matter of lot of debates before different courts. In fact, I just also spoke about the Supreme Court, which laid down that principle that any retrospective amendment with respect to these policies is not a good law, and hence most of these policies, when these have to be seen, and I'm not concluding that the principle of promissory estoppel, whether that comes into play or not, but of course, the vested rights of the individuals or the SSCs would come into play. What was the guiding objective of the scheme at the time of the pronouncement or at the time when it was opted by the businesses will have to be seen as well. So these are all various interesting aspects which needs to be examined for a lot of these policies when it comes to the Indian exporters and the entire foreign trade policy framework. The next issue, for instance, goes into the non-availability of ITC on non-fulfillment of export obligations. So what happens in certain cases is that the transition has happened from the erstwhile regime to the GST regime. If there is a non-fulfillment of export obligation, in the erstwhile regime, it was very clear that on non-fulfillment of the export obligation, you pay the tax, whatever that tax is, and you would be eligible to take the credit of that tax if it is convertible, or whether in those cases wherein you are eligible to take the benefit of credit. Now, what has happened under the GST regime is that when there is a case of non-fulfillment of export obligation, there are provisions which restrict the credit of ITC to the Indian exporters. And this has been challenged by us in Delhi High Court. What we are saying is that for especially those licenses which were issued prior to the GST coming into play, in fact, this should be, according to me, applicable even to those licenses which are coming into play after the GST comes into play, because the objective of GST is not to have tax cascading and to have free flow of credits. If there is a restriction or non-availability of ITC due to non-fulfillment of these export obligations, the challenges need to test the constitutional validity. And that's exactly what the situation today is before the Delhi High Court, to decide on the constitutionality of the restriction when it becomes applicable in case of non-fulfillment of export obligations by the Indian exporters. The next case is with respect to the social welfare surcharge and cesses on imports using duty credit scrips. So we know for a fact that there are these duty credit scrips which are being used, and as far as the social welfare surcharge or other cesses are concerned. So how these cesses are computed? So for instance, if I have an MEIS or a SEIS scrip, and I use these scripts to pay my basic customs duty, and when I use these scripts to pay my basic customs duty, the notification says that to the extent of that basic customs duty applicability, there is an exemption. The notification very clearly lays down the principle that the amount offset by these scripts is nothing but an exemption. So which means in effect that basic customs duty becomes zero in those cases where these scripts are used. The question is that if the basic customs duty is nil, whether social welfare surcharge, which is nothing but a tax on the basic customs duty, would also become nil, because we know for a fact that anything which gets multiplied with zero becomes zero. So if basic customs duty is zero and there is a specified percentage of social welfare surcharge which is to be made applicable on basic customs duty, which is zero, then any percentage on zero would become zero. And especially in light of the fact that the notification which has been issued specifically says that there is an exemption with respect to the basic customs duty when it is used against the duty credit scripts. In those cases, the question was whether the social welfare surcharge actually becomes payable or not. After these writ petitions were filed, and we argued with respect to applicability of social welfare surcharge at all on those transactions wherein these scripts are being used, there is a circular which has been issued, and that circular predominantly says that is basically adding insult to injury. And what it says is that, one, social welfare surcharge is payable. Secondly, what it says is that you can't even use the scripts for the social welfare surcharge. Interestingly, the circular says that the social welfare surcharge cannot be paid for these against these scripts only prospectively, and for the period prior to issuance of the circular you could use that, and if you have used that there will be no demand. Now I am not able to digest that at all, because if it is not to be used, it can't be used even for the earlier period. And from that perspective, even this circular has been challenged by me in one of the high courts, wherein what we are saying is that the circular is completely arbitrary. It is completely a case of adding insult to injury. While we are arguing that social welfare surcharge is not payable at all, the circular goes ahead to say that social welfare surcharge is payable, and social welfare surcharge cannot be paid using the duty credit scripts, I think, which is again the fundamental question which has to be addressed by the courts. So that's where the problem arises, is because the intention at the time when these schemes or these scripts were given was something else. Based on that, the entire costing has happened, pre-order costing has been finalized, and then at a later point of time we realized that this becomes a cost, and hence is a situation wherein the businesses run out of profits because profits are wiped off because of these issues. So that remains an issue. The last point which I want to address before I open the discussion is with respect to the certificate of origin. And we know that when it comes to the foreign trade agreements, the certificate of origin are very, very important document. So India, as we know, has a lot of these foreign trade agreements with different countries. Of course, there are certain problems when it pertains to imports in certain cases, wherein the certificate of origin is very, very relevant. So, for instance, there could be a product, let's say cocoa, and when India imports cocoa, India may have foreign trade agreements with some countries in Southeast Asia, for instance, Singapore. Now, if the amount of import of cocoa is Singapore, which is, let's say, 100,000 tons, we know for a fact, based on data, that Singapore cannot produce that much quantity of cocoa. And in terms of the value addition, it appears that cocoa is being diverted from different countries to Singapore and then coming into India. So rightly so, I think the Indian government recognized that problem with respect to the origin, and the Finance Act 2020 granted the Customs Authority the power to question the origin of goods and cast the responsibility upon the importer to exercise reasonable care. Now, the problem which is today is that what is this reasonable care, and possess sufficient information. When the matter comes with respect to the reasonable care, I could actually take the information from my supplier that this is the produce of that specified country. But if the problem goes beyond a point that the reasonable care has to be proved, and I need to prove that the origin is that country, then it becomes a big problem. That is one. Secondly, also what happens is the provisions state that mere furnishing of a certificate of origin shall not absolve the importer of its responsibility. Now, the question which arises is that, one, I have to rely on external agencies for getting issuance of the certificate of origin. But if the law says that I will not be absolved from my responsibilities, it becomes a big issue for the Indian importers, because then the Pandora box can open at any point of time with respect to these certificate of origin. And at future, I may have to shell out a lot of this money in case there is some issue with respect to the certificate of origin. Also, we need to very, very carefully understand that we have today foreign trade agreements with different countries, and there are conditions very different for different agreements with different countries, which could basically differ with respect to different countries, different products, different quantities, and so on and so forth. Now, this provision has come by way of a proposal in the Finance Act, and which is a general provision. Now, what needs to be seen is that whether this general provision could supersede the conditions which are there in a specific foreign trade agreement. And if that's the situation, then clearly the foreign trade agreements will overrule the provisions of the Customs Act, and that's when the challenge will start. So as we know that there are already a couple of show cause notices which are issued by the revenue to question these certificate of origin, which are the subject matter of dispute before different courts for the period prior to this amendment. So there are already challenges with respect to these certificate of origin. Now, after this amendment is enacted, there will be a double problem, because then the Indian importer will have the responsibility also cast upon him. And if that's the situation, then it may not be a good situation for a lot of these cases, especially wherein the foreign trade agreement may or may not have a diluted condition. But the Customs Act as a general provision has a very strict norm with respect to the certificate of origin. So I think from that perspective also, these matters become important to be seen in light of the specific provisions of the specific foreign trade agreements, specific products, specific timing, and different such conditions. and then only all of these conditions could be made implemented. Till the time these issues are there, the court intervention would be required for many such issues. So I think that's the broad framework with respect to a dozen of these important constitutional matters which are going in different courts in the country. And with respect to the global perspective, how India now goes into appeal and how the WTO Appellate Forum decides this issue with respect to these subsidies will have to be seen very carefully. But what is very important to be seen is that for a lot of these schemes, such as the Advance Authorization Scheme, which is not a problem as far as the WTO case is concerned, I think those schemes, the benefit should be extended in full flow. And India has been very clear that it is not a case of subsidy contingent on export performance. So from that perspective, our argument is very clear. We are ready to face it out in a very systematic and a pragmatic way. But we are also very clear that the qualification of these as prohibited subsidies is not the case, which is being argued there at the WTO. So pragmatically, what we have done in a way is to convert these schemes to, as far as this MEIS is concerned, to gradually phase out MEIS. As far as the SEIS is concerned, to tweak it, to convert it to the remission of duty scheme. And hence, this new scheme has been approved by the cabinet in March of this year and is expected to be operational by the end of this year or probably early next year. But the flavor will be very clear that these are remission of duties or taxes on the export product, and this will predominantly aim to neutralize taxes on inputs, which is very clear that the Indian government stand is, and it is not to offer export-based rewards. So which means India is very clearly moving towards a global pattern. We want to adhere to the norms of the WTO, but at the same time, we want to keep our stand very clear at the international forum that it is not the case of the prohibited subsidy which India is providing, but it is a very clear case of remission of duties. The good thing is that with this case which is being argued, India is being looked as a nation wherein other countries will have to depend us on both imports and exports. Today, the global economy knows that they can't work without collaborating with India. Also, in terms of the numbers, it is being proved that as far as India is concerned, we have crossed GNP of $1,000 for the period 2013 and 15 and 14 to 16. So from that perspective, also the image of the country is changing. But as far as the technical legal interpretation of this subsidy versus the prohibition is concerned, we will maintain our stand that this is a case of remission of duties, which aims to neutralize the taxes on the inputs. Now, if that's the intention, wherein the government at the global level wants to argue that the government wants to neutralize the taxes on inputs, I see no reason that the executive today should deny the benefits with respect to these schemes which have been promised under the foreign trade policy, these different schemes for the Indian exporters. And hence, it becomes very relevant for the courts to intervene at appropriate point of time to support the Indian exporters. Indian exporters have been facing a lot of trauma at the customs port for compliance hassles, for refunds and so on and so forth. But at the same time, fortunately, courts have intervened to provide specific directions to the jurisdictional officers and other bodies that these benefits have to come in the way these have been promised. So from that perspective, I think we are, while we are living in unprecedented times, we all need to be very optimistic because courts have time and again come to the rescue of the Indian exporters. On that note, I would take a pause and would go back to the questions so that I could address the questions posed by you. Are there any questions which are being posed?
Mr. Rastogi, actually, I checked the screenshot also. So when you see the tab, there's a before the leave event, there's a 3 dots coming. Just look at the cross.
Yeah, that's right. Yeah, 3 dots are coming.
Just click on that 3 box.
Q&A.
Yeah.
And click on Q&A. Okay, perfect. I've got it. I've got it. So let me go to the Q&A. I've got all the questions now. So I think my voice was breaking sometime. I'm really sorry. In case somebody feels that on a particular aspect, I need to probably emphasize a little more, I can do that right now. You can ask that to me and I will repeat that. Shimpi Gupta is writing that can the duty credit script MEIS, SEIS be used for payment of concessional duty for imports done through project import route? It's very, very clear that these MEIS and SEIS scripts can be used only for specified duties. Now, this through the project import route, there are restrictions which are there under specific headings. Now, when those restrictions are there, these cannot be used, unfortunately. But what you will have to see is that whether these are related to the customs duty and they fall within the bracket of the customs duty. And if they do that, then you would get the benefit. So this will be very, very case specific, wherein you will have to go through that provision to see whether you would fall within the customs which is eligible for the usage. Now, the related point which I mentioned was that if the duty credit script is being used for customs, the related point is that what happens to the social welfare surcharge and others which are made applicable on the customs duty, and in your case, the project import route also may have a lot of those welfare surcharges and cesses. So the question there becomes more relevant from the constitutional perspective, because that challenge with respect to the constitutionality of that restriction will come into force, Shimpi. Now, Smita has posed a question that when IGST exemptions allowed in August 17, it was only for physical exports. Is it now applicable for deemed exports too when pre-import condition is removed? Now, when we are talking about the restrictions of the pre-import, those pre-import condition was made applicable to different schemes, including the advanced authorization licenses schemes. So the question was whether this pre-import condition be made applicable, and if it is made applicable, then what that condition is. First, we need to decide that what that pre-import condition actually is. And of course, when this IGST exemption was allowed, you are right, in August 17 or October 17, in that period, it was only for physical exports. So of course, the physical export has to be made. But the question is whether there has to be one-to-one correlation between the imports made under the advanced authorization scheme and the physical exports. So from that perspective, it needs to be seen whether that one-to. So the challenges with respect to the vagueness of this condition. Another question which has come is, this I've seen. If we forget to put EPCG number shipping bill, can we use those shipping bills discharging EO? It's a very nice question, Ganesh. Substantive benefit cannot be denied due to a mere procedural lapse. We have seen Supreme Court decisions and different high courts decision in that regard. So even if you forget to do that, you will not be denied the benefit towards discharge of the export obligation. In fact, we have gone ahead and said that for those cases where we have completely forgotten or it's an inadvertent error, then also in those cases, it becomes a vested right and the benefit should not be denied, because the substantive benefit cannot be denied due to a mere procedural lapse, which is a settled law. So Ganesh, from that perspective, yes, you can intimate and take the benefit. we have settled DRI notice, I think it must be DRI, not DIR, along with interest under protest. Can we claim interest in case of judgment in favor of exporters? Now, Nipun, very, very clearly, this question I cannot ask. We need to see whether the benefit with respect to the constitutionality comes for the petitioner or it is read down. If the provision is held to be unconstitutional, of course you may get the benefit. If the provision is not, if the provision is held to be constitutional, but is read down in some way so that the benefit is extended, you may not get the benefit. So ideally speaking, if the pre-import condition is decided in favor of the exporters, you would get the benefit with respect to the payment along with the interest. But I think depending on the quantum of the money which is at stake, I think you will have to move to the writ court with respect to the entire problem of pre-import, so that when the benefit comes, it comes to you as well. But having said that, there is a high probability that you would get back the interest in case the issue is decided in favor of the exporters. But you need to consider whether you need to go to the court for this issue or not. With respect to the IGST exemption, whether that is applicable for deemed exports, that will have to be completely dependent on the scheme which you are taking, the product and so on and so forth. There are certain notifications which would determine or decide whether this benefit can be given. But as far as the IGST exemption is concerned, this remains a vague area and will have to be seen for each of these specific products, whether this benefit can come or not. Yes, Nipun corrected by saying DRI. I read that. Now, there is another question. Now, Shimpi is writing that as per ICES clarification number, DCS can be utilized for payment of concessional duty in project import. However, Mumbai and Chennai customs are not allowing the use of GCS in PI cases. They are insisting on local customs notice for the same. And I think in that case, you can straight away go to the court to say that this benefit has been denied, and you can ask the court to intervene in these cases so that you get the benefit in this case. The next question is very interesting. Nipul is writing, can we claim MEIS which are old than 3 years? However, these could not be claimed due issues related to shipping bill transmission from customs to DGFT. Is there any provision for manual application of lapsed MEIS? This will have to be argued basis your vested right. The period which has been prescribed, which may come as a limitation, may not act to deny you the benefit, but this benefit can come to you only after examining the facts and also only after the court intervention. So this is a good case wherein your matter can go to the court. I think you should analyze this so that the court intervention and direction comes with respect to this benefit. Writing about surcharge which was paid through MEIS scripts. Brand rate is sanctioned after withholding the social welfare surcharge components by customs. Can this be challenged for seeking refund of SWS which was paid through scripts? This is a perfect case which can go to the court and can be challenged. Aditya, there is no doubt about it. You would be eligible to get this benefit, and court intervention here will certainly be of help to you. Manish is writing why advance authorization scheme is countervailed in CVD cases in US, EU, and other countries if it is WTO compliant. Now, advance authorization scheme, as far as this advance authorization scheme is concerned, even under the WTO dispute between India and the US, advance authorization scheme, there is no restriction. The entire dispute which pertains to is with respect to the EOU, EHTP, STP, BTP, SEZ, MEIS, and so on and so forth. DFIS scheme has also been under dispute, for which 90 days from the date on which the report is accepted was given. Now, as far as duty-free import schemes are concerned, duty-free import authorizations are completely different from the advance authorization licenses, and we need to understand that as far as the this advance authorization licenses and DFIA licenses are concerned, duty-free import authorizations are based on SIAN norms. These are transferable, and these pertain to those cases where goods may not be physically incorporated. So these are very, very different from advance authorization. And from that perspective, as far as the WTO challenge is concerned, WTO has not extended the conflict with respect to the advance authorization because these advance authorization schemes are very, very clearly different from DFIS schemes. Manish is writing, I think that's the same question. Shimpi is asking, if an importer is not able to fulfill export obligation under advance authorization due to liquidation of the customer, is it pay differential duty and interest for such imports done? If an importer is not able to fulfill export obligation due to liquidation of the customer. So what I understand is that export obligation and it is because money has not been able to pay differential duty and interest. Unfortunately, the provision says that you need to get that money to make to fulfill the export obligation. While I understand this is a case of hardship, but that's the problem. You will have to live with it. But you could actually write to DGFT and ask for a clarification whether, from your perspective, that bad debt which has happened due to the liquidation of the customer, would you get the benefit? But to the best of my understanding, I think they would not give you the benefit in those cases with respect to the liquidation. Ultimately, the objective of meeting the export obligation is not fulfilled in those cases. So I've answered Aditya Shankar's question with respect to the social welfare surcharge. I will move on to the next. Smita is asking, I am for settling the claim DGFT is asking to submit no due certificate from all respective other government authorities. It would be very difficult to get such certificate from all customs authorities and GST or excise authority. How to deal with this situation? See, I think the best way to deal with such situations is to file the writ of mandamus. You need to be very, very vocal in terms and very, very clear in terms of the written communication with these different government authorities. If the communication is very different and they're not acting on the request, which is very, very for getting the benefits under different provisions, you could file a writ of mandamus making all of these a party to the problem, and they will thereafter adhere to the court's direction. Rahul is writing, we being an importer, shall we purchase and use scripts for payment of basic import duty since they are going to be phased out soon? What points we should take care? I think I would not do any forecast with respect to the phase out. Yes, the phase out is on cards. But I think you could purchase only to the extent of only to the extent you feel you will be able to utilize in the near future or with respect to the procurements which you have in hand. Target plus supplementary claim. Smith is writing something. So I think That's what are the questions which we have. So I think we can take certain more questions. And I also received the feedback that there was some breaking of the voice which happened during a particular phase. So in case you feel that I need to take any such petition or any such part which was probably not heard clearly, I'll be more than happy to do that. In fact, in any case, I will be sharing this document with you, which will give you a flavor of these writ petitions, which are very relevant for this foreign trade policy. And you could always write back to FICCI or email me in case you have certain questions. And I think this document would be very, very useful to you from the perspective of understanding this entire controversy at the global level and before the courts in India. So I think with that, we can end our session. But happy to take any further questions, but looks like we have exhausted all the questions.
Yeah, Mr. Rastogi, just let me check with if there are any other questions. We can just check. Yeah, if there are not any other. Is my you hear my voice? Can you hear me?
I can, yeah, I can hear you, but it's slightly breaking.
Okay. Yeah. So I'm saying there are no more questions now. In fact, a lot of questions are there, which you have put in during the session only, and you have taken all of them. So, I mean, we don't see any questions further in the Q&A box.
Sure.
And I think with this we can close the session. Before this, I would really like to thank with Khaitan and company for taking out his time and agreeing to the masterclass, this very pertinent session on foreign trade policy. He was so we are really grateful that you have really agreed, and I mean in whichever initiatives that we have been taking, your you have really supported many of our initiatives. So this was indeed a very useful discussion. All the aspects, the important information, insights that you have shared with us today is going to be really useful, and we look forward to such interactions in future. I would also like to thank all the participants for taking out their time and attending this master class for policy. With this, would be have any further or any like to starting the webinar, we would really welcome that. With this, we the end of the session. Thank you everyone for your time once again. Thank you everyone. Take care. Bye bye.